Welcome to Lapin Law Office's virtual law office, being brought to you from Dallas, Texas. In this video, we'll explore the reasons why Texas attorneys oppose the use of standardized court forms. Before we begin, let's define what we mean by standardized court forms. Standardized court forms are those pre-printed check-the-box and/or fill-in-the-blank forms that are authorized or approved by a state or federal court for use in conjunction with a legal proceeding. We're not talking about the forms that you can download for free or buy on the internet or at a stationery store. Here, we're talking about forms that the court itself approves and in some situations even mandates that litigants use. According to the Texas Supreme Court, 48 states have implemented some type of standardized family law forms. Other states, not Texas, but other states, have approved standardized forms for cases such as adoptions, civil harassment, civil theft or conversion, discovery, domestic violence, fraud, judgment enforcement, name changes, pleadings of all sorts, contracts, evictions, personal injury, property damage, wrongful death, probate, small claims, and others. But not Texas. On November 12, 2012, the Texas Supreme Court issued an order, the substance of which was contained in a single paragraph, which approved a set of standardized forms, quote, for use in uncontested divorces that do not involve children or real property, unquote. Texas Supreme Court's stated reason for approving these forms is to improve, quote, accessibility of the court system to Texans who are unable to afford legal representation, unquote. But even as narrow as that approval was, two state Supreme Court justices dissented. The November 2012 order resulted from a recommendation of a task force that the Supreme Court had appointed in March of 2011 to evaluate, quote, the need for statewide standardized forms for pleadings frequently used by pro se litigants, unquote. The task force was instructed to, quote, consult with and seek input from stakeholders, unquote. One of those stakeholders was the family law section of the Texas State Bar, a group of Texas divorce lawyers. The divorce lawyers claimed that allowing pro se litigants to use standardized court forms would implicate, quote, fundamental legal issues that average laypersons will not be able to resolve by themselves. In other words, the divorce lawyers said that the average pro se litigant is not capable of representing himself or herself. But as the Texas Supreme Court noted, 48 states have implemented some type of standardized family law forms. Although it is true that some self-represented litigants will not have the ability to properly handle their cases, that is not a sufficient reason to deny all litigants the use of standardized court forms. What are the benefits of standardized court forms? Well, first, it makes it easier for those who want to represent themselves to do so. Second, it makes it easier for those who cannot afford to hire a lawyer to represent themselves, even though they may not want to do so. And third and finally, and this is why the family law lawyers objected, using standardized court forms will result in market-driven reductions in attorney's fees. How so? Quite simply. Once clients have the option of using standardized court forms, they will no longer be willing to pay their lawyers large sums of money to draft custom forms when a fill-in-the-blank, check-the-box form will do just fine. There's an old joke about a complaint a client made about his bill for attorney's fees. It goes something like this. The lawyer wrote a letter on behalf of the client, solved the client's problem just with one letter. Then he sent the client a bill. The bill said, draft letter, $1,000. The client objected. He says, what, you're charging me $1,000 to write a simple letter? The lawyer said, okay, I'll revise the bill. The revised bill looks something like this. Draft letter, $1. Knowing what to say in the letter, $999. Which tells us that the practice of law is not filling in a form. It's knowing what to say. The practice of law is knowing what facts are relevant. It's knowing what law is applicable to those facts, and it's knowing how to best present the relevant facts and applicable law to a court, both in writing and verbally. Completing check the box and fill in the blank standardized forms is simply not the practice of law.